Hey guys, sorry I'm late. Here's what's gonna happen. I am tired from working all day, and these lights have been on my face all day. So I'm gonna turn the camera off, but I'm here, as you can see. Oh god, this is just like it's giving me a headache. And I don't want to look like a freak in the dark, like a creepy basement guy. So I'm just gonna turn the camera off, but we're gonna go over these documents really quick. I don't have too long, but we'll skim through them. Okay. So this discovery, they were trying to extend the schedule for discovery. I thought that was going to be like a done deal because the parties didn't really object. But hold on, let me show you this. I guess they're going to have like a hearing on Teams. It'll be another public dial-in hearing, and it'll be what, Tuesday? Let me see, Tuesday, yeah, at 3:30. So everybody can call into that like last time. Although the last one was honestly pretty boring to me, but um, we'll see. I'll probably call into this one and just see what they have to say. Sorry, I'm trying to catch up on all this stuff. I am here. I am right here. I'm fine. I want her to talk about our feelings. Your feelings. Oh God. I don't know. How are you feeling? I don't know. Hey Leanne, what's going on? Hey Donna. All right. Let me switch over to this. So there's a protective order relating to Blake Lively's deposition. If you guys remember, they were arguing about the location of it. And so they're going to try to make their case for why it should be at their location of choice, and why they think like the Wayfarer parties are being unreasonable. So we'll go over that real quick. Hang on. I got to zoom in a little bit so you can see that. That should be good. That might actually be a little too close for me. I need to drink some water. Give me 1 sec. Okay. So some of this is redacted, obviously, you can see, but like we already knew, her deposition is scheduled for Thursday, July 17th. And they're asking for a protective order directing the Wayfarer parties to conduct her deposition at, and then there's the location they don't want us to see, and to disclose the identities of all individuals who will appear. Ms. Lively regrets the need to burden the court with this request, and does so only after defendants have refused Ms. Lively's reasonable requests, and instead insisted that Ms. Lively's deposition take place at, and then it's redacted. As far as identities of people who will appear, I did say that I would be interested in appearing, so I don't think that's going to happen, though. Defendants, no, that's not a thing. Defendants have not denied that their intent is to manufacture a harassing publicity stunt by requiring Miss Lively to parade through paparazzi, I see, or by inviting unknown attendees to the deposition, including members of the media or social media influencers or any other number of abusive tactics. Wait, hold on. That's not a real thing. Nobody's really inviting influencers to this shit, are they? Because I would agree that that's a little... Nah, I wouldn't do that. No, I wouldn't. But I've never heard them say that they were going to do anything like that, so that's quite fucking random to me. But what do I know? I've never seen the deposition in person, so... Despite Ms. Lively's repeated efforts to confer, defendants have refused to address these concerns and have responded only with their insistence that they alone control all logistics and security issues. The repeated efforts to confer bit, I don't think that's true. No, because we've seen the back and forth on that, and I don't think that's true at all. But... All right. Defendants' failure to acknowledge the real security and privacy risks ignores that they have engaged in retaliatory harassment that has extended into the litigation itself, including by defense counsel's repeated and personal attempts to turn Ms. Lively's deposition into a media event. Good cause exists to provide Ms. Lively with these basic protections. The court may, for good cause, issue an order to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. Ms. Lively respectfully requests the court order defendants to respond to this motion on an accelerated timeline. Since virtually the inception of this litigation, defendants have used even the prospect of Ms. Lively's deposition to generate press interest. Defense counsel publicly demanded the earliest possible deposition of Ms. Lively in advance of the first court hearing on January 30th, resulting in a predictable wave of sensationalized press coverage. On May 8th, 2025, Mr. Friedman made unprofessional comments to People magazine about Ms. Lively's deposition, preposterously, declaring that he wanted to hold it at Madison Square Garden, sell tickets, or stream it. Now, listen, I thought that was a funny comment. Like, I laughed at that. I thought that was funny. But if that were my attorney, I don't know if I'd be thrilled about that because of this right here. So it's a little. Uh, because it was obviously a joke, yes. And I thought, like I said, I thought it was funny. But if I were, this person's client, I would maybe want them to be a little more careful because she is a huge bitch who will spin anything into a threat. So, I'm not like psyched about that at this point. As a spectator, I was thrilled and I thought it was hilarious, but that's just me. So, all right. And that if Miss Lively is willing to sit for a deposition, I am available. How does tomorrow morning work for her? Just days after defendants noticed Miss Lively's deposition, Mr. Friedman sat for a lengthy interview with TMZ, in which he announced, I've noticed her deposition. It's set in June. We're going to see if she's going to appear at that deposition or not. Okay. During a conferral on June 13th, defense counsel insisted that Miss Lively's deposition must be the first deposition taken. Okay. Miss Lively agreed and offered July 17th, which defendants accepted. On July 7th, Ms. Lively's counsel emailed to confirm the plan for the upcoming deposition, consistent with the practice adopted by the parties for other depositions scheduled to date. For security reasons, Ms. Lively's deposition will be held, and that's redacted. Separate and private breakout spaces will be provided for attending parties and counsel. So we read that email, so I don't need to go through that, but we read that like yesterday. Okay. Opposing counsel responded by insisting, without any articulated reason, that the deposition take place at redacted. Ms. Lively's counsel immediately responded that they had made security preparations to hold the deposition at wherever, an approach that aligns with, and then a whole bunch of words I can't see. Defendants did not respond. Lively's counsel sent another email the morning of July 10th asking for confirmation whether you agree to conduct the deposition at redacted and to identify all attendees in advance, no later than tomorrow. That evening, counsel for Ms. Lively emailed again stating, you have not agreed to our reasonable request to hold the deposition at, nor to advise us in advance who will be present at the deposition. You have provided no reason for refusing these basic courtesies, so we can only assume that it is because you intend to make a media show of Miss Lively's deposition in some way, both inside and outside of the deposition room. Listen, I was totally joking when I said I would go to that. No, when it comes to like depositions and stuff like that, I would not think it was appropriate to put a whole bunch of media people in there. But I'm not a lawyer. I've never done shit like this before, so I don't know. But to me, it just sounds like, I don't know, it does sound like kind of a spectacle. One that I would totally, again, as a spectator, love to see. But I kind of, as far as this goes for both sides, I would think it was inappropriate for a bunch of media people to sit in on Justin's as well. The thing is, I don't really trust what they're saying. I don't think that they do intend to make a media show out of it. So I don't want to take their words at face value here. I'm just kind of thinking out loud. And I think maybe it should just be like more of a, it shouldn't be such a public thing, I guess. Like, don't invite random influencers and shit. And that goes for both sides. I don't know. That's just my opinion. So, all right. Defendants have not attempted to demonstrate the cost, convenience, or litigation efficiency warrants holding the deposition at redacted rather than at other redacted. Let's see. Nor can they. We're going to skim through some of this stuff. Nor can defendants in good faith claim any need to hold the deposition at redacted, given Mr. Friedman's willingness to conduct it at Madison Square Garden. And again, that was obviously a joke. So it's really frustrating that they're putting that here. But he did say it. So unfortunately, I can't be like, well, you made that up. You know what I mean? Because he did say it. He just wasn't serious about it. Holding the deposition at redacted will save defendants resources, because Ms. Lively's counsel was already engaged with professionals to ensure safe and professional conditions, including by, and I'm not going to, there's, a bunch of blocked out words again. 1 second, I need a drink. Sorry about that. Defense counsel's insistence that he can take Miss Lively's deposition anytime and anywhere belies any claim now that holding the deposition at redacted is essential to convenience or efficiency. Again, that's why I hate this comment so much, because not that I don't know that he was joking. Obviously, it was a joke, but these people are obviously going to take it and use his words against him. And with this judge and the way he's ruling, I think it's going to backfire. I don't think this is going to go the way that I want it to go. Let's put it that way. And unfortunately, I think it's going to be because of that joke a lot. All right. Likewise, no cost, inconvenience, or inefficiency is generated by requiring the disclosure of the identity of attendees. To the contrary, it is essential to know in advance who plans to attend, not just for building security purposes, but also given that any testimony will be presumptively sealed under the protective order, and ultimately may be designated as confidential or attorney's eyes only. Defendant's insistence on holding the deposition at redacted and withholding the names of attendees subjects Ms. Lively to unknown security and privacy risks. The high-profile nature of this litigation and the nature of Ms. Lively's retaliation claims demonstrates the substantial risk of the deposition turning into a publicity event or potentially attracting interested individuals who could pose security risks. Mitigating against these risks requires extensive and expensive professional assessment, planning, and staffing. Defendants do not appear to have considered such security concerns, instead baldly asserting that, I don't know what that says, because it's redacted, which is difficult to square with Mr. Friedman's public comments about this deposition or allegations that have been recently made about Mr. Friedman's unprofessional conduct. Is this a Vin Diesel thing? I think it is. In a sworn affidavit filed by an attorney in a case before the Los Angeles Superior Court. I believe they were saying that Brian Friedman was aggressive in some way or threatening in some way or somehow said he was going to fight someone. I'm not sure if that's accurate. I'm just saying that's what I gathered. So I'm going to have to, and that thing was 400 pages, so I haven't had time to look through that. Not that I won't, because I will. But I just really hate that his words are being used to make their case right now. It frustrates me. So, yeah. But I don't know. I have to look into the Vin Diesel thing, like I said, because I don't know exactly what was said and in what context. So I probably shouldn't judge too harshly there. All right. I see a lot of people saying the Vin Diesel thing is stupid. I don't, obviously don't disagree with that. I just haven't read it. So, all right. Let's see. I was just my place. There it is. A case in which Mr. Friedman refused to allow his client to be deposed at opposing counsel's law firm based on the inadequacies of plaintiff's counsel's office to protect defendant's personal safety and privacy. In light of the above, this court should grant Ms. Lively's reasonable request to prevent the risk of annoyance, harassment, and verbal or physical threats. Well, Ms. Lively thinks making eye contact is a physical threat, so I mean, there's really nowhere she's going to be safe, I guess. Defendants have not refuted that manufacturing a public spectacle is their motivating factor in refusing Ms. Lively's request for the whatever the fuck that says. Unable to host Ms. Lively's deposition at Madison Square Garden, or to sell tickets or stream it, defendants appear to seek another public relations moment or to create conditions for intimidation or harassment. I find this really hard to take seriously after they just leaked to ZMZ a bunch of celebrity, or not even celebrity, but influencer subpoenas. I'm a little annoyed by that, but whatever. Ms. Lively respectfully asks the court to enter a narrow protective order to minimize security and privacy risks and to preclude defendants from using these proceedings to promote public scandal. Okay. And there's something that goes along with this with some communications that are pretty interesting. So we're going to go over that. Just give me 1 second. So this most recent one is from 24 hours ago. I want to make sure I get to them in order. I think we have to start at the bottom. Yeah. All right, so this was Monday. We might have seen this one though. So yeah, we did. So this was when they were arguing about the footage and how all the footage hasn't been produced. Remember that Blake's attorneys had written that there were 50,000 hours of footage that needed to be produced, which is absolutely stupid. Like one of the most stupid things I've ever seen. It's less than 150 hours. We had speculated. I asked my friend Aaron, who works in film, about it, and I asked some other people I know who work in film, like how many hours do these things usually go for? Not this film, but I just asked them generally about film, and the speculation was that it was at most going to be more like 5,000 hours or something. And I heard lots of different things. I heard someone say less than 10. So, but apparently it's around 150 or something like that, less than 150. So 50,000 was a reach to say the least, man. Oh, is Omar in chat? What's up, man? I'm gonna try to go over to Omar's family law after dark after this, so I'll probably redirect you guys to that when we're done. But I don't want to reread these emails that we've already seen, so I'm gonna get to the newer stuff. But I just need to skim over it, make sure I don't miss anything. Yep, because it's 100 terabytes. They determined that 100 terabytes, after talking to tech people, I don't know where they find their tech people, probably fucking Temu, but 100 terabytes to their tech people was 50,000 hours of film, which is over 5.5 years. Like, okay. You actually said that with your whole chest. 2 different lawyers. One in an affidavit. Or not an affidavit, a declaration or whatever. That it was 50,000 hours. Yikes. Okay. But we'll skim over this one then because we've already seen it. We've actually already seen the location that's redacted here was actually not redacted in another filing, but it's not that important because I'm not a creepy stalker, so I'm not gonna show up there. As much as I like to pretend that I could see it. All right. Let's see. We saw this agree to postpone, whatever, blah, 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 because they're arguing that Wayfair is trying to make it look like she wants to postpone, but that she actually doesn't. So they're just arguing back and forth about who's being sketchy here. Give me, you leave Temu out of this. Man, have you ever ordered anything from Temu? Like, come on. It's not the best. It's not the best. It's not unusable, but it's not the best. Oh, Bushbirds are here. What's up, guys? Appreciate you. I'm so confused on Vin Diesel. Yeah, me too, man. Give me 1 second. I just need a drink of water. All right, sorry about that. Okay. We saw this one. Following up on my email below, please confirm by noon today whether you intend to go forward. Yep, we saw that one. Mitra following up. Let's see. As I mentioned, we're prepared and eager to go forward with Miss Lively's deposition next Thursday, July 17th. We therefore will not mutually agree to reschedule that date. That said, we understand this is your deposition, and if you choose to move the date, you may do so. That decision, however, must be made and communicated to us no later than 5 p.m. Eastern today. Our team fully intends to go ahead and has already incurred significant expenses to prepare for and travel to wherever for the deposition. If we do not hear from you by 5 p.m. Eastern, confirming whether or not the deposition will proceed, we will seek sanctions against the Wayfair parties for all costs incurred to further prepare for and travel to the deposition, including without limitation associated attorney's fees, costs, and travel expenses. We are otherwise able to discuss deposition scheduling for other witnesses. And remember, their big problem in their filing was also like they won't give them dates for when they want the Wayfair guys to do their depositions. So that was a little weird. Let's see. This is from Ellen Garofalo. We will proceed with Blake Lively's deposition on July 17th. We remain convinced that in the light of the new scheduling order delaying the completion of discovery, it makes sense to continue the deposition until all discovery is complete. That way, we would avoid any argument that Ms. Lively could not properly prepare, and most importantly, any objection or instruction not to answer based on the claim that certain documents have not yet been produced, and or there has been insufficient time for plaintiff's counsel to review the files, particularly the film footage, where they were arguing to the judge that she should have the film footage and all that beforehand. So in this vein, Ms. Lively has objected, among other things, that the footage produced lacks sound. And they sent them all the footage. They just didn't send them the audio to the footage, which is a little funny to me. But, again, I don't know how normal that is. So, in this vein, Ms. Lively has objected, among other things, that the footage produced lacks sound. We produced the raw footage in compliance with the ESI protocol. However, in order to fully cooperate with discovery, we will agree to provide footage which marries the sound to the images on the condition that you will agree not to argue that in processing this footage to marry the sound and picture, the Wayfarer parties have somehow manipulated evidence. We are happy to provide any information on the technical process to avoid any misunderstanding. Please let me know if you're amenable to this agreement. In any event, since we cannot agree to continue the deposition, at Ms. Lively's insistence, we will proceed on July 17th. Please feel free to call me if you have any questions or wish to further discuss this matter. Okay, they wrote back here. Ellen, if you believe it makes sense to continue the deposition until all discovery is complete, then you should do so. You seem to want us to weigh in on your decision, but we have no obligation to make that assessment for you. It is, after all, your deposition. You decided that Ms. Lively be the first deponent, and you selected this date. And if you decide to move forward, that too will be your choice. Well, they did say they were not going to go forward if they didn't have all of that. They said you have to give us the you have to give us the tracking number and all that for this footage and when it's going to be here before we agree to do this. And then they said there was processing delay, so they couldn't get it to them by the date and time that Blake's counsel demanded. So then in my head, when I read that, I was like, well, they couldn't get it by the time you demanded, so that means you refused because you said the only way you would cooperate is if they got it to you by this time. So to me, that, that's a little weird. I don't know. We'll see. And you will be held accountable for your own strategic decision in the event you later decide that it would have been advisable to have scheduled Ms. Lively's deposition later in the discovery period. Ms. Lively will not sit for deposition a second time based on your strategic miscalculations. This is your deposition, and you have both the right and the obligation to conduct it in a manner that you understand will be consistent with the court's instruction that no witness in this case will be deposed more than once. Given the limited time left before July 17th, we have respectfully urged you to discontinue all posturing and gamesmanship around the scheduling of this deposition so that we can address the needs of not just our client, but numerous attorneys whose schedules are in limbo as a result of your numerous requests that we reach a mutual agreement to postpone Ms. Lively's deposition. At this point, however, the posturing and continuing because your email below states that you will proceed with Ms. Lively's deposition on the 17th, notwithstanding your requests or reservations and your clear preference to move it. You have not agreed to our reasonable request to hold the deposition at blank, nor to advise us in advance who will be present at the deposition. You provided no reason for refusing these basic courtesies, so we can only assume that it is because you intend to make a media show of Ms. Lively's deposition in some way, both inside and outside of the deposition room. If we don't hear otherwise from you by 12 p.m. PST tomorrow, July 11th, which was today, we will promptly file a motion for protective order, which is what we're looking at right now. At that time, in which we will ask for the court to order these clearly warranted parameters to the deposition. Likewise, if you later move the deposition, we will seek sanctions against you and your clients for the costs and fees we have already incurred in preparing for the deposition on the date you have repeatedly affirmed you intend to keep. We continue to not understand why you seem to be unable to simply state honestly and directly that you're requesting that we reschedule Ms. Lively's deposition date and to request that we meet and confer on a mutually agreeable date to reschedule. We further do not understand why you refuse to accommodate our completely reasonable security and location requests. We remain open to such discussions if you choose to proceed in a reasonable manner. Otherwise, we'll seek relief from the court by noon tomorrow. And then Ellen just responded, what was it? Talk about posturing. In any event, we expect to see Ms. Lively at 9 a.m. on July 17th, redacted for her deposition. Yeah, that's funny. All right. Yeah, so that was pretty crazy. It's funny how her personality comes out via her lawyer's words. Sometimes, man. Sometimes. They aren't writing to the judge, they're writing to the public using the court system like it's the New York Times. I'm gonna be honest, I think they both do that a lot. I think they both do that a lot. So, see, chaos in her mind. Thank you for the 5. Andy just posted a recording of the call to Ezra's office. The court hearing with the judges, 15 public and creators can all dial into. Perez gives details. Yep. So the court hearing, if you go to the beginning of this, and you look at the blue text on the first document I pulled up, they don't have the details for the public hearing. As far as Andy's recording, I've seen it. I've also reached out to them. They did not respond to me. Their office, Ezra's office, will not give a clear answer as to whether or not the subpoena to Google was legitimate. I feel like if it wasn't, why would you not just deny it? It's all very strange. And then of course, YouTube support and Google support have had multiple reps now say, no, this is a real thing. It's just really chaotic. So I feel like I'm not really talking too much about what I want to do with that until I get a straight answer from someone. Because the date on mine said July 31st. I know some people got one that said the 15th, but I do not, have that time crunch. So I'm gonna chill out a little bit. All right. Shannon Connell, thank you very much for becoming a new member. I appreciate you. Let's see. Gwen, thank you for the 10. Lauren, we all love you and here to support you. Take this for a drink, gummies, or whatever you feel like to help you through this mess. Man, I want some I want something with salt. But thank you. Thank you. Irrelevant Photons, thank you for the 5 for your legal fund. Appreciate that very much. And Christina E, thank you for being a new member. I appreciate you. All right, guys. Let me see if Omar's got his thing set up yet. If he does, I'll push you over there in a second. I just gotta search him up real quick. Whoa, that's too much to take. I can't imagine how Baldoni put up with this behavior. Yeah. They won't give you a straight answer because they're waiting for the judge to take their side. Man, I don't know. I don't know what the deal is with that. It's all very strange. So I don't know. Like I said, I will talk about it more when I get a straight answer, though. All right, one sec. Yeah, it looks like Omar is on now. So let me push you guys over there. Make sure you tell him that I sent you and give him some love. I'll be over there in a little bit. I just gotta take a quick break. Just redirect. There it is. All right, guys. I'm going to end this now, but it'll take you over to Omar's if you look at the link that's going to pop up when I end the stream. And I will be over there in probably like 15 minutes or so. So thanks, everyone. Appreciate you. And I'll catch you guys soon, probably tomorrow. Bye.